Bolton, members of the council, guests and friends, it's my pleasure to welcome you on this absolutely lovely evening, which I remarked to someone probably gives us more competition than a snowy night or an Orioles baseball game, but we're delighted to see all of you. Let me remind you that our next program will be in early October. Ambassador, early November.
It'll be one of those nights.
It's you can't get away with anything here, but which is good. In any case, early November, Ambassador Lee Hong-koo of the Republic of Korea will be with us. One slight modification: we had anticipated a program on Pakistan on November the 30th. All right, and the ambassador, as you know, is no longer the ambassador of Pakistan. We still very, very much want to have a program on Pakistan and India, since certainly the challenges to diplomacy in that part of the world are extraordinary, and it'll be a fascinating test case. So we do anticipate a program on Pakistan soon. But on November the 30th, Governor Glendening will join us here, not as a substitute, to be sure, but as the program. Thinking of the challenge to diplomacy in South Asia and the extraordinary place that diplomacy can play in the life of nations, of course, that is not in contrast to, but somewhat different from, the question of the role of international law within an international nation-state system, or even perhaps in the role of it in modifying the nation-state system. In any case, this evening's topic, which has to do with international law and the question of sovereignty, and especially American sovereignty, is our topic, and it's a fascinating one. We're delighted that Mr. Bolton was good enough to join us to discuss it. Mr. Bolton is a native of Baltimore, by the way, which I didn't know until this evening. So he remembers from his youth the Inner Harbor before this building was here, and we're absolutely delighted to, and he's a McDonough graduate, which reminds me of one of our former trustees, Carl Wallace, who many of you knew, was an absolutely splendid trustee, and also McDonough graduate. In any case, he's a graduate of Yale College, summa cum laude, graduate of the Yale Law School as well, 1974. He's been a partner in two of the major law firms in Washington. He served in the Reagan administration in a number of capacities, including as an assistant director of the AID. He also served as a assistant attorney general in the Justice Department, working both as the assistant secretary for legislative affairs, and then later of the civil division, the largest litigating part of the Justice Department, of course. And in the Bush administration, had a series of interesting, a very fascinating job, that of Assistant Secretary of State for International Organization Affairs, which put him in touch with all the affairs of that department, the creation and execution of policy within its various agencies, and a number of interesting times, as you recall, including the Persian Gulf crisis of 1990 to 91. So he brings, and he continues to write, I should say, in the area of international law, international politics. So he brings the perspective of the law, of practical experience, to this very important theoretical and practical question of international law and American sovereignty. It's my enormous pleasure to present Mr. John Bolton.
Thank you very much. It's a pleasure to be here this evening. I want to thank all of you for coming. It's certainly a pleasure to be back in Baltimore. I want to try and cover a fair amount of ground in a relatively short period of time. So you'll forgive me if some of the points I'm going to make are necessarily condensed, and I'd be happy to try and expand on some of them in the question and answer period. But getting into questions like what is law could take a relatively long amount of time. I don't plan to do that. I want to hasten to assure everybody this is actually a much more interesting topic than the title implies, in large measure because I do not view the conduct of foreign policy largely through a legal prism. I think it is essentially politics on an international scale, and indeed it is my concern with the overemphasis on law as a means of dealing among nations, and the, in some cases, naive, but in other cases, dangerous misapprehensions that people have about that that can lead to substantial difficulty for the United States. Now, I think we are, and have been really for much of the past 6 years, at a very critical time in our own internal deliberations in the United States on the question of how the United States relates to the rest of the world. What is our place among the nations? And I think it's not surprising that we are having this debate. It is the third time this century we have had it. First time after World War I in the debate over the Versailles Treaty and U.S. membership in the League of Nations. The second time after the conclusion of World War II and the debate over the United Nations and the Bretton Woods system. And now, at the successful conclusion of the Cold War, we are having the debate again. Now, there is a conventional wisdom about American policy in this century based on the first two of those debates. And the conventional wisdom goes that Woodrow Wilson, who was elected his second term by promising to keep us out of war, just to remind you of that, that Woodrow Wilson had a vision for the post-World War I world that was cruelly defeated by a bunch of knuckle-dragging isolationist Republicans known as the Irreconcilables, led by Henry Cabot Lodge, whose narrow-minded view of the world kept the United States out of the League of Nations and thus led to the Second World War. But under the renewed leadership of Franklin Roosevelt, although he didn't live to see his creation come to fruition, the knuckle-draggers were defeated and the United States joined the United Nations. Unfortunately, in this idealistic and inevitable march of progress toward peace in the world, the Cold War intervened, and unfortunately the vision of Wilson and Roosevelt had to be put aside. But now that that minor inconvenience is out of the way, we can return with full vigor toward accomplishing Wilson's objectives. And in fact, the Clinton administration came to office much as its immediate predecessor in the Democratic Party, the Carter administration, had come to office. Many of the same people in the Clinton administration having served as younger officials, more junior officials in the Carter administration. The Clinton administration came to office with the promise of a policy that it called assertive multilateralism. Now, I was never quite sure what assertive multilateralism meant, and I'm not quite sure they were clear what it meant. But when they tried to explain it, this is what they said. I just want to quote one sentence from a speech in September of 1993, that is to say about 8 months into the administration, from Tony Lake, who was then the National Security Advisor. And he said, and I quote now, that he hoped that the habit of multilateralism would one day enable the rule of law to play a far more civilizing role in the conduct of nations as envisioned by the founders of the United Nations. Now, I cite that because I do think that there is a clear pattern of continuity about the role of multilateral institutions, the role of international law through this century. And I think it is a debate that I will say in the most radical fashion that I can, a debate that has two sides. It is not a debate about isolationism versus internationalism. That's the way some people would like to characterize the debate. And I think that is flatly wrong and terribly misleading. I don't mind saying that my view in this debate, which I consider thoroughly internationalist, is skeptical of multilateralism, at least multilateralism as I want to explain it a little bit more fully, and skeptical as well about international law. Now, I can't talk about international law with at least a couple of minutes here on why I don't think it's law. And I'm going to tell you at the front end, this is not the war and peace version of my thinking on this. But I want to just describe it very briefly. International law essentially comes in two forms, at least to those who really believe in it. One is in the form of treaties, which purportedly have binding international legal obligation, and the second in the form of what's called customary international law. And let me deal with treaties first. The idea that a treaty, a written agreement between two or more countries, really functions as law, I think is erroneous because in the international context, there are simply no mechanisms, such as we have right down the street here, to resolve disputes about who made the law, what the law says, who's complying with the law, and what the penalties are for violating the law, whether it's civil or criminal. Now, the absence of those institutions, and I might say the absence of any democratic accountability over the formulation and change of law, are not simply minor omissions. They go essentially to the core concept of what law is. Treaties, therefore, don't bind in any less of a moral or political sense, but it is a mistake to think that they are binding as law. And it's a mistake because we as Americans are a very law-abiding people, by and large. And I think that we tend to make the mistake that if we're law-abiding and we've signed a treaty and we're complying with it, that all the other 180-odd nations that would sign a global treaty would also comply with it. It's just fundamentally wrong. Let me just finish on the treaty question by giving you 3 sentences and saying 2 things about those 3 sentences. Because I don't want you to get the impression that my disparaging international treaties as law means that I would not sign any treaties or that I would disregard treaties. Let me give you my 3 sentences about treaties. America is morally bound by its treaty obligations. That's sentence 1. Sentence 2, America is politically bound by its treaty obligations. Sentence 3, America is legally bound by its treaty obligations. Now let me just say 2 things about those 3 sentences. Those 3 sentences say 3 different things. They are not the same. You can be morally bound, you can be politically bound, and not legally bound. The second thing I want to say about those 3 sentences is that sentences 1 and 2 are normally true, and sentence 3 is false. Let me give you an example. Probably the most important, the most solemn treaty commitment that the United States made in the aftermath of World War II, the most important treaty commitment we've abided by for 50 years, is Article 5 of the North Atlantic Agreement, which essentially says that an attack against one NATO ally is an attack against all, and in effect binds us to come to the defense of the country attacked. Now, I think that the obligations we assumed under Article 5 are morally binding. I think they're politically binding. I think an American president should honor those commitments, but I think it's a mistake both conceptually and operationally to think that he's legally bound. Now let me give you an example from the Cold War. Most of our strategists thought that the Warsaw Bloc's attack against the West would come through the Fulda Gap in Germany. So imagine the following conversation. The chancellor calls the president and says, the Soviets are coming through the Fulda Gap. Just wanted to let you know, I'm invoking Article 5 of the North Atlantic Agreement. And let's assume the president said, well, I'm sorry to hear that. I've been looking at the treaty and our various commitments, and I've got a health care plan here that requires me to balance the budget, and you know, I'm sorry, but we're not going to comply with our Article 5 obligation. Now, does anybody seriously think that the German chancellor would then say, well, that's that's really outrageous. I'm going to take you to court. I'm going to get an injunction. You've acted illegally. Of course not. And that's not what really has force in the treaty world. The second major way in which international law, so-called, is created is what's called customary international law. And if you asked people in the 18th and 19th centuries, that's basically what they thought international law was. Customary international law is state practice. What do nation states do? How do they perform over time? How do they behave? Elevating customary international law into something that's binding, however, assumes that you can derive law without anybody necessarily having consented to it, without anybody being able to say definitively, we got together and we agreed on this. The idea that state practice evolves over time such that it creates a really clear body of law assumes that at some point customary practice gets so crystallized that state practice can never change again. Now think about that. If the customary law derives by state practice, who is it that decides you can't change anymore? And how did they get that authority? And did any of you vote for them? I don't think so. A friend of mine, Attorney General Bill Barr, who once was, when this was first explained to him, said he was somewhat puzzled by it. If you are, you're in good hands, so was a former Attorney General. He said, now let me get this straight. You're saying that the only way you can change customary international law is to break it. And in fact, that's right. What we ought to consider customary international law to be is international custom. What are we fighting over? What are we fighting over? We're fighting over the emotive force of the word law. And we're fighting over it because for Americans, it means a good deal. I would argue that law that crystallizes like customary international law, and that's a word that international lawyers and analysts use to describe it, I would say that law that just crystallizes out there is not acceptable to a free person. If you listen to the news from Washington and they said, well, law crystallized in Congress today, I think you'd be a little bit skeptical. You should be a little bit skeptical. Who crystallized it? And when did they do it? And when do you get a chance to hold them accountable? These are examples, and I want to come to some specifics, but these are the conceptual weaknesses in the notion of international law that when you fit into this habit of multilateralism that the Clinton administration was trying to pursue, that I think leave us vulnerable, not simply from a national security point of view, but from the point of view of what I think is at the core of sovereignty. And that is the question, who governs? Who makes decisions about things that have the force of law that govern our conduct? Do we make them? Do our democratic, our constitutional decision-making structures make them? Or are they made some other way? I am willing to concede the force of law to rules that go through a defined constitutional process that's based at bottom on popular accountability. International law doesn't meet any of those tests. Now let me explain and get off the theoretical level here. Let me explain how I think this works in practice and how it has worked in the recent past. The environment for the last 5 or 6 years really began about 20 years ago during the Cold War, when the explosion of international organizations, codes of conduct, international conferences and declarations was really flourishing in the late 1970s. Things like the New International Economic Order, which was a slogan of the non-aligned movement, the underdeveloped countries. It was really a way of transferring wealth from the North, the developed countries, to the South. The New World Information and Communication Order, which was a way of developing codes of conduct for the press and journalists to make sure that they transmitted news in a balanced and even-handed fashion around the world. Things like the law of the sea Treaty, which was negotiated in the late 1970s in an effort to put the entire seabed under common ownership and put the right to exploit mineral and other resources in the ocean under United Nations control. All of this taking place at a time in the United Nations characterized by very harsh anti-American rhetoric and other resolutions directed against our closest allies. For example, the absolute bottom of the United Nations, in my view, occurring in 1975, when the General Assembly voted by a quite extraordinary majority to equate Zionism with racism. Now, when President Reagan came into office, he essentially rejected the idea of the new international economic order. He rejected the emerging legal norm of an obligation by the developed countries to commit 0.7% of their gross national product, and don't ask me where that number came from, but that was the number they used, 0.7 of our gross national product, which had to be delivered annually in the form of foreign aid. He rejected that. He took the law of the sea treaty and he said, we're not going to sign it. He rejected codes of conduct for international business. He voted against one of the first things I was involved in at the Agency for International Development, a code of conduct at the World Health Organization for the sale of infant formula around the world. And he basically said, I'm just not going to participate in any of this. Now, the effect of Reagan's rejection was that it basically came to a halt. The countries that were including some in Western Europe that were pushing it basically gave up on it. And it disappeared from the radar screen, which I think is an instructive lesson of in what you can accomplish if you're willing to take a broad conceptual picture, as President Reagan was. Now, because at the same time the rest of the United Nations political decision-making structure had been frozen by the Cold War for nearly 30 years at that point, the economic and social development and these international norms about human rights and economic policy were basically all on the same level. That is to say, none of them were functioning. But a very interesting thing happened during the Bush administration, during the Persian Gulf crisis, when President Bush, in a kind of a marathon diplomatic effort, persuaded the Security Council to authorize the use of force to repel the Iraqi invasion of Kuwait. Following a series of other resolutions in the Security Council and active diplomacy around the world that built an international coalition to support the United States-led military effort. Now, the significance of this vote was that it gave a sense of legitimacy to a lot of people who were very nervous about what it was pretty clear President Bush was going to do, whether he had Security Council authorization or not, which is take out the Iraqi army. As General Powell once said when describing our strategy, first we're going to cut it off and then we're going to kill it. And that's what President Bush was preparing to do. But in the meantime, he assembled this international coalition, and for only at that time, the second time in UN history, obtained Security Council authorization to oppose international aggression. The first having been in Korea in 1950, when the Soviet Union was boycotting the Security Council to protest the fact that Communist China didn't have the China seat, the nationalist government on Taiwan had it. And they, in one of the worst blunders of Soviet diplomatic history, stayed away from the Council, didn't exercise the veto, and we got an authorization to use force in Korea. That was in 1950. The second time it happened was 1990. Now, the result of the, and I might also say it was a very useful domestic political tool for President Bush as well, because following the Security Council authorization of the use of force, Congress then followed with the use of force, authorizing the use of force. We used to say Finland was a member of the Security Council in 1990. And we used to say we got Finland to authorize the use of force against the Iraqis just before we got Congress to agree to it. But one of the results of the of the visible success of using the United Nations in the Persian Gulf crisis, I think, was that many people misread the lessons of what had actually happened there. And they, instead of seeing what I would describe as a very successful effort at international coalition building by an experienced and effective American president, they saw that it was the United Nations itself that had somehow become effective, and that it had found the resolve and the wherewithal to oppose and eventually repel the aggression. I think that's clearly incorrect. But many people drew that lesson and assumed that the promise of the United Nations, I'm now back in my debates this century, the promise of the United Nations had suddenly flashed back to 1945 and we could start all over again. And I believe that this was a really very much at the heart of the feeling of the incoming Clinton administration. I quoted to you from National Security Advisor Tony Lake some key officials in the administration. Mort Halperin, who's now, he served in a variety of positions, he's now Director of Policy Planning at the State Department, had written the year before he joined the Clinton administration that the United States should renounce unconditionally the first use of force for anything. The United States would simply say, we will never use force first. Now, I just want you to remember that and put it in the footnote when we come to Kosovo. The administration also said that UN peacekeeping was going to be their preferred approach. You remember I talked about assertive multilateralism. That is what they at least proclaimed at the beginning that they wanted to do. And in fact, in a very clear case of a straight line between an idea and a policy, they began to implement assertive multilateralism in Somalia. You'll remember that at Thanksgiving in 1992, because of the humanitarian tragedy that was unfolding in Somalia, President Bush announced that the United States would lead a non-UN but U.S.-led military intervention into Somalia for humanitarian relief purposes, and said that the duration of the American-led effort would be only as long as necessary to allow the distribution of humanitarian relief and to get the Somalis basically to negotiate among themselves to get a political settlement, to put their country back together again. And indeed, it was contemplated that it would last a matter of months. When the Clinton administration first came in, they seemed to be following the Bush plan, basically. You'll remember there was a cover of Time magazine in first 4 or 5 weeks of the Clinton administration with the president marching across the White House lawn with some returned American troops from Somalia. But that policy was very explicitly changed to give the administration an effort as part of its policy of assertive multilateralism in Somalia to engage in what they called nation building. And they made it very clear that the UN-led effort, which was headed in Somalia by an American, appointed at the request of the Clinton administration, would carry this out. The Somalis had effectively at that point lost any coherent central government. They were engaged in it barely can be called civil war. It was a kind of fratricide at the clan and sub-clan level. And the administration said, we're going to put this country back together. Now, that effort basically pushed the United Nations and the United States into taking sides in Somalia, taking sides with this sub-clan against that sub-clan. I might say none of these warlords that we were dealing with were terribly appealing. I'm not defending one or criticizing others. I'm just saying that to try and put things back together, it meant taking sides. And the result was 18 dead Rangers in Mogadishu in the fall of 1993. That and the congressional outrage when the administration sent the Secretary of State and the Secretary of Defense to Congress to explain what we were doing in Somalia, and they couldn't do it. Led the administration to say, we're going to pull out of Somalia entirely, which they did early in 1994. Now, I think that was the end of nation building as a real tool of policy in the administration, because they were unable to tell Americans what I think is a president's basic moral duty when he uses American force, which is to say to the parents of the Americans whose lives are at risk why their sons and daughters are being placed at risk. And when the Secretary of State and the Secretary of Defense met with every member of Congress, it was a big room under the front steps of the Capitol, an auditorium where they all met, and I've heard from Democratic and Republican senators and representatives who were there, they simply couldn't articulate a reason why those young men had died. The entire effort was abandoned. Now, despite the collapse of the nation-building effort in Somalia, and despite the fact that assertive multilateralism disappeared from the vocabulary of the administration, the policy, in effect, continued. And I want to just read again what Tony Lake had said, that the habit of multilateralism would enable the rule of law to play a far more civilizing role in the conduct of nations. Now let me fast forward through Haiti, through Bosnia, through a variety of other places to Kosovo. Now let's just stipulate for these purposes that the government of Yugoslavia, the Serb government of Slobodan Milosevic, was committing atrocities in Kosovo, and that it was intended to and would at its earliest opportunity ethnically cleanse as much of Kosovo as it could of ethnic Albanians. What the administration did, and made a very conscious decision to do in the face of this, was not to go to the Security Council to seek authorization, not to seek permission of the government of Yugoslavia, but to launch NATO on a war against the government of Yugoslavia for the asserted purpose of preventing crimes against humanity, which, as I say, we'll just stipulate for these purposes the Serbian government was committing. So NATO's first hot war was conducted with no Security Council authorization. I think it was permissible within most people's definition of international law, but it was completely contrary to everything that the Clinton administration had said about assertive multilateralism, the role of the United Nations, the role of the rule of law. In fact, in the case of the NATO air campaign over Yugoslavia, and I'm just going to leave out all the questions like, did we actually do more damage in Kosovo by allowing Milosevic to conduct his ethnic cleansing even while we were dropping bombs on his country? I'm going to just leave all of that out of the debate to focus on the policy and legal issues that the administration basically ducked. Now, it is that contrast that I think, and I don't say that to say, I'm not going to go on from that to say, and that proves that the Clinton administration is hypocritical, although I think it is. I think what it shows is that however you define what our interests are, even the United States is going to pursue those interests. It's going to pursue it in what it believes to be an accountable fashion from its own domestic point of view. And it's not going to get hung up on aspirational notions of international law. What people who supported the NATO air campaign argued, at least some of them, was that indeed there was a duty of humanitarian intervention when crimes against humanity were being committed, even if it were entirely within the bounds of a sovereign state. Now, this is a very hard doctrine to argue with morally, that you've got a duty to intervene to render humanitarian assistance. But I just want to point out that it contradicts, last year was the 350th anniversary of the Peace of Westphalia, which is usually taken to be the doctrinal origin of the concept of the nation-state as we know it. And I don't know when we had a vote to say that the Westphalian state had suddenly been rendered obsolete by this need, this duty, this obligation of humanitarian intervention. And I think the point that emerges from this is very clear, is that what suits your interest can be made to sound like law without raising a sweat, and that is a very cautionary note for people who really think that these rules of law have any true impact, even on a very democratic country and law-abiding country like the United States. Now, if you think what effect these notions have on other countries that don't even have a pretense of law-abidingness, the rogue states like North Korea, Libya, Iran, Iraq, and others, you can see why the notion that we have, that of course we're law-abiding, and we sign international obligations, and we abide by them, and so of course everybody else will as well, can be not just naive, but really very dangerous. Now, where does all this go from here? We are facing right now a series of international agreements that some people argue already have the force of law as customary international law, but which in any case they believe that the United States should sign and ratify and come into compliance with. When we agreed to this topic and this date, I certainly had no idea that the Senate was going to vote on the Comprehensive Test Ban Treaty last week. Neither did they, I think, at the time. But the fact is that the vote on the Comprehensive Test Ban Treaty, to me, is an excellent example of the playing out of exactly this question of the faith that you have in international law as binding and as safeguarding our national interest. Now, I don't want to, in the limited time we have, get into a substantive debate about the merits of the Test Ban Treaty itself, whether it left us unable to test and therefore unable to verify our nuclear stockpile, and therefore undermine the credibility of the U.S. nuclear capability, which I think is an incredibly important force in peace and stability in the world. But what I think we can say, or at least what I hope you would all agree with, is that reasonable people of good faith felt that there were legitimate scientific and military reasons to oppose this treaty. And despite what some people have said, I think in an effort to delegitimize the position of the opponents, I don't think it was simply political motivation that led them to vote against it. And that is, it really does frame the debate. Do you think that a treaty that nuclear states like Pakistan and India haven't signed is going to lead them over time to follow these emerging international norms, or do you think they're going to do what's in their national interest? Senator Lugar of Indiana, who's a very well-respected observer of arms control over the years, said very flatly, and I think very convincingly, of course they're not going to abide by it. They're going to do what's in their national interest. Other rogue states, for example, Iraq, Iran, that signed the predecessor non-proliferation treaty, just flatly ignored it. And there's no reason when you have a history of that kind of willful violation of earlier treaties to think that signing another treaty is going to make them any more law-abiding than the exercise of signing the earlier one. This is, as my colleague Richard Pearl, I think, very aptly described it, an example of, to use a domestic analogy, of the cops and the robbers sitting down to negotiate a peace treaty. Now, if you really think that all nations are going to perform equally, then you at least have a logical basis to say we can trust everybody else to comply with the treaty. And I would just observe that there'd be few in this audience, or indeed in most audiences in America, that would say we're going to sit down and negotiate with the criminals. That is almost surely a path to destruction. And I think the same can be said about the Comprehensive Test Ban Treaty. the vote against the treaty, I think, is a very powerful symbol of the unilateralist feeling but for exactly the reasons I said earlier, not an example of isolationism as some would portray it. There isn't any argument that, at least I don't think there is seriously, that the overwhelming consensus in the United States Senate is against nuclear proliferation, that we are safer, all of us, in a world with fewer nuclear powers. The question is, how do you get to that point? Do you get to that point by signing a treaty, or do you get to that point by assertive American policies that involve not just non-proliferation in some circumstances, but counter-proliferation? I think we face a very similar kind of argument in a range of other areas. The administration has negotiated and signed the Kyoto Protocol on climate change that imposes enormous obligations, if it were accepted as domestic law in the United States, on our energy and other policies that would have a substantial effect on our standard of living, but really wouldn't bind many other nations in the world, particularly those in the developing world that are not placed under binding obligations. The Kyoto Treaty is another one of these that, if brought to the Senate today, I think would be defeated. And there are others: the Landmine Convention, the Statute of Rome creating the International Criminal Court, a range of issues like that I think have come into the wall of, hit the wall of realism in foreign policy. This is something that is not a dispute about ultimate objectives. This is not a debate about whether we want a peaceful and secure world, but it's very much a debate about the most effective way to get there. And I think this is something that we can and should have in our presidential debate in the year 2000. The supporters of the Test Ban Treaty said after they lost the vote that they wanted to make it an issue in the presidential campaign. And I hope that it is an issue because it is, in my view, emphatically the case that we are talking here about issues that do go to the heart of American security, but also, and I want to come back to my basic point about sovereignty, that go to the question of who makes the rules that apply to us. Are they made through our institutions, which are based on popular accountability with effective constitutional structures, or are they made in international negotiations with governments that don't, to be blunt about it, meet our democratic standards, that don't have our respect for the rule of law, and are we to trust in that potentially to our own detriment? I personally don't think so. I think the vote on the Test Ban Treaty was an excellent signal, and I hope that it will lead us out of this policy of assertive multilateralism that we have been following the past 7 years, and back to a policy of affirmation of American interest. I think this is a potential turning point for the United States in the world. I certainly recognize there are going to be some different points of view here in the audience. I just want to close by saying I appreciate this opportunity and I look forward to your questions.
Well, we thank you for a very sophisticated, interesting, and challenging presentation. Mr. Bolton will call upon you and he'll repeat the questions.
The question is basically what I think of the world. I think the question is what I think of the World Federalist Society's slogan of world peace through world law. And I guess I would say that the slogan ought to be world peace through American strength. I think that the fact is that let's take one other institution I didn't talk about that was created after the Second World War, picking up from its League of Nations predecessor, the International Court of Justice. The rhetoric about the International Court of Justice in 1945 was that this was a real substitute for a resolution of disputes among nations, and therefore they wouldn't have to resort to force. The experience of 55 years is that the court is a miserable failure. the selection of the judges, their votes on the courts are all highly politicized. I don't mind politics in international affairs. I think that's what it's all about. And so when the International Court of Justice votes along predictable country lines, and you and I could sit here and probably agree on 95% of how the votes are going to come out based on what country the judges come from, I think we ought to consider that for what it is. It's not an International Court of Justice. It's a kind of mini, it's not a mini, it's a larger than the Security Council and far less effective. I think the question of how you move from national institutions, nation states, to larger international organizations of government is one that there's no satisfactory answer to. I certainly don't think the United Nations system has come anywhere close to it. The one example we have at present is the European Union, and I think I agree with the assessment of those who have described the increasingly powerful central institutions of the European Union and the European Commission as being unacceptable and unaccountable from the perspective of democratic theory. The Europeans have, the French, after all, developed the word bureaucrats. They like being ruled by executive bureaus. The European Commission is a French creation almost from start to finish. But you can see when you get below in Europe the level of elite opinion and just ask people like us, average voters, they're much more negative on the institutions of the European Union than their political leaders. So even where you have all democratic countries attempting to make this transformation, I don't view it as entirely successful, and I don't think as a matter of what would be acceptable to Americans who believe in more strongly than they do in Europe in popular accountability and have it spread much more broadly through our institutions than they do, that we would even come close to accepting that. The question is, can't we distinguish between political treaties and economic treaties that have disputes resolutions mechanism? And I would say, I mean, obviously you ought to look at every treaty and every organization on a case-by-case basis. I think that there is a stronger argument in the case of the World Trade Organization that it is sensible and something that we can live with. Although I must tell you, I am disturbed by I believe in free trade. I believe I'm not a protectionist at all. But I am concerned about the dispute resolution mechanism in the WTO as being something that is outside of acceptable levels of popular accountability. The way the mechanism works, it's not actually binding because a nation, a signatory of the GATT, participant in the WTO, can refuse to accept the decision. Sanctions may then flow from that from the other members, but what it shows is that fundamentally it's still basically a political tug and pull. And I think that's basically what's going on here anyway. I think to the extent that that one has made more progress in the commercial area, that really is a better model, though, that we might be able to accommodate ourselves after years and years of experience in a way that I find much too risky in a very theoretical way, like the proposed new International Criminal Court. I don't rule out some kind of evolutional growth in this area, but I think that the experience we've had to date shows that it's very unlikely on these more fundamental issues. The question is, do I think that the success of the United Nations in the Persian Gulf War will lead to basically having it acquire more power in other contexts? And I don't know if I'm misstating your question, but let me put it a different way. I don't think the United Nations accomplished anything in the Persian Gulf War. I think the United States used the United Nations as an effective instrument of American diplomacy as part of President Bush's coalition building, and that the vote in the Security Council gave legitimacy for people who needed it, like a lot of people in Congress, that I don't think we separately needed. The mistake that I referred to that people drew, the mistaken conclusion from the experience of the Persian Gulf War, was that there's a there in the United Nations. What the United Nations does is what its member governments want it to do. And in the Security Council in particular, what the 5 permanent members want it to do, and in particular, to be perfectly blunt about it, what we're able to get the others to do. Where the United States exerts leadership in the Security Council can function. Where it doesn't, it won't. And I just think that's a fact. The question is, why should, I think, if I may paraphrase, why should the rest of the world trust us to do the right thing? And it's a fair question. The answer I would give you, why, and your further question is, why is it not in our interest to advance international law more generally, even if it may be in our to our short-term disadvantage? And I would say that that there is in the world, and I think it's an opinion shared by a substantial number of people in this country, that the nation state generally is actually the problem in the world, and that it's the nation state that has caused the conceptual and operational existence of the nation state that's caused much of human conflict over the past several centuries. I just disagree with that. I don't think the nation state has caused international conflict. I think human beings have caused international conflict, and if they weren't organized in nation states, they'd find another way to have conflict. As a senior official of the International Committee of the Red Cross once said, "What can be more human than war?" That is a fact of our background. I think that in the interest of the United States is actually different than the agenda of those who are trying to tie down the nation state. I think there's a feeling that what they really want to tie down is the United States. In France, they have they now routinely, politicians on both the right and the left in France, refer to the United States. We call ourselves the world's only remaining superpower, to the point where we're all probably tired of it. They've gone beyond that in France. They call us a hyperpuissance, a hyperpower. And if you want to know what they think that means, think of words like hyperthyroid. I mean, that is not a compliment. And what they have in mind by binding us through international obligations is limiting our ability to act unilaterally. You know, I am certainly willing to concede as a matter of general principle that the United States' unwillingness to be bound into this kind of system would lead other nations to say the same thing. The difference is that other nations are going to say that, and the problem nations in particular are going to say, sure, we'll be bound by that treaty and that treaty and that treaty. They just won't pay any attention to it. Whereas I think our conduct would actually be more law-abiding whether we signed on to some of these treaties or not. My point is that it is conduct and interests and power in world affairs played out through politics that determines outcomes, not the pretense that we're operating in a law-based environment the way we are domestically. The casual export of concepts of domestic law into the international arena is not just naive, it really is dangerous. The question is, what are multinational corporations going to do to our ability to compete? Yeah. I think that there are a lot of people who are leaders of American corporations, what we think of as American corporations, traded on American stock exchanges, owned by Americans, headquartered in the United States, staffed at the top levels by Americans, that are increasingly global in their perspective. I'll give you an example. Coca-Cola, the CEO of Coca-Cola sits on the AEI Board of Trustees. Coca-Cola's, I don't know if any of you drink Pepsi or anything, but sort of it's viewed as a symbol of the United States around the world. Coca-Cola no longer has a United States division, has a North America division. I don't view that as a bad thing. I think that is the kind of, to return to the question the gentleman asked earlier, that's the kind of opening up that occurs gradually and over time that I don't have any trouble with. I think there are legitimate questions that people have asked in the case where our companies are open to take over by foreigners, whether we have the same possibilities in return. When Daimler buys Chrysler, I think that's a good thing. I think it opens markets. I think it expands competition. When Deutsche Bank buys Bankers Trust, I have no trouble with that at all. I do want to be sure that if one day one of our companies buys a European company, that in fact they're able to go ahead with it. Or even when two American companies merge, like Exxon and Mobil, whether the European Commission is going to let them go ahead. That will, to me, answer the basic question whether this openness to global markets, in fact, is going to work. I think America will be open, should be, as it's an anti-protectionist stance, to those kinds of multinational acquisitions and joint ventures and the whole range of other possibilities. I think it is fair to say it remains uncertain at this point whether the Europeans, the Japanese, and others are as open as we are. And I think that is something that we need to watch. The question is to what extent are multinational corporations really bound by environmental and human rights restraints in other countries, and how do they comport themselves in the face of those kinds of constraints? I don't argue, and indeed I don't need to argue, that business, whether it's a small business or a multinational corporation, is any more moral than anybody else on the planet. I think what they will do and what they're judged on is their economic performance. And the consequence of imposing some of these constraints on them is that often more by well-meaning Westerners than by the inhabitants of the countries involved themselves, is that if you put stringent environmental constraints on overseas investment, or you impose human rights obligations, so-called, and I don't necessarily admit that that's exactly what they are, they're just going to invest somewhere else. I mean, that is the point of this 0.7% transfer obligation in the new international economic order I mentioned a few minutes ago. If you can't, or at the beginning of the talk, not a few minutes ago, but if you can't force somebody to invest, then these kinds of constraints are going to lead them to go somewhere else where their return on equity is going to be more satisfactory to their shareholders. I can tell you the story of one major oil company, not one that you mentioned, that wanted to run a pipeline out of Chad through Cameroon to drill oil in Chad, a desperately poor country in Africa. Cameroon not much better off. The revenues generated by the production of oil in the pipeline would have had a very substantial positive economic impact on those two countries. They have been so overwhelmed with environmental constraints and so-called human rights constraints that it's not entirely clear that they're going to go ahead with the project. Now, the net of that, if they don't, is they'll invest somewhere else and they'll pump the oil somewhere else, and the people of Chad and Cameroon will get no economic benefit. This is, I don't mean to oversimplify this. In fact, my point is that frequently the oversimplification occurs in the other direction. Simply by saying something is a pro-environment regulation or pro-human rights regulation, I think oversimplifies the complicated world that we live in, and it to me is not always clear just from the labels what the right decision is. I guess I should say there, thank you very much.
Well, we certainly thank you for what I think was a super as opposed to a hyper presentation tonight.